Today, we're going to work through a number of topics really focused on the high net worth individual in terms of structuring in the US and abroad, and a lot of the tax issues, especially on the estate and gift side, faced by wealthy individuals. The overview agenda will break everything down into 5 sections. We're going to first look at structuring. Structuring over the last 8 or 10 years has really kind of been refined now. We really know how to get the high net worth individual into the structure appropriate to their situation. The reality is that 5 or 6 family situations tend to capture almost everything. We'll go through LLCs and trusts and different titling. We'll talk about how trusts differ from LLCs. We'll get into some detail on domestic and foreign asset protection trusts in section 2. And in section 3, we'll go through an overview of the differences in some of the estate and gift and the income tax issues that high net worth people face domestically and internationally. And then we'll get into some of the more exotic issues on expatriation and pre-immigration planning in sections 4 and 5. We've done entire treatises on a number of these topics, so we're trying to hit the high points so that you can take away either with respect to red flag issues regarding some of the advisors on the line, some of the CPAs and attorneys. And then for the individuals on the line, these are things that you should watch out for and follow up with your attorney and or your CPA so that you can catch any issues before anything develops. The first section is the structuring section, the asset protection side. And we look at asset protection. This is a slide we've used for a long time, basically as a way of dealing with future lawsuits that we're not trying to avoid currently. So if we're in trouble now, that's a completely different issue. But in terms of people, and by far the 99% of the people that come to see us really don't have any problems. They're just curious. Well, if I have a problem in the future, how do I deal with it now without losing control or without giving up much control? That's always the issue. And we can do that now in a number of states and offshore jurisdictions. We're not hiding. We're not running away from anyone. We're just holding title in a way that's protective in case they do have litigation. You use 4 different areas of asset protection, which are titling. Everyone's familiar. Titling is very common in terms of the entireties. In other words, husband and wife titling is the big red flag issue. In other words, if husband and wife take title to an asset and it's properly titled and the entireties are actually conformed with, in other words, they take it as husband and wife, no one owned it first, it's not a transfer from one to the other, you actually have to start with the ownership as husband and wife. There's these entireties you have to follow. But if you do it and you title in husband and wife, if one spouse is sued, the asset is not available. That's not joint tenants, that's not tenants in common, that's by the entireties. And that's in Florida, that's allowed both for real estate and personal property. So you can do your bank accounts, your securities accounts, and your real estate. In many states, that's not the case. And we've got high net worth individuals in a number of states and countries that have opened up, for instance, a securities account. And they say, well, we just want a joint account. They think that there's protection. But in that state, we had one in Ohio some time ago. They don't offer tenancy by the entireties for securities accounts. So what happens is if one spouse is sued, you lose the account. You lose either the account or half the account based on the fact that it's not protected. Exempt assets, very common exempt assets or the homestead in Florida. Several states exempt the homestead, but only Florida has these unlimited exemption. Life insurance, annuities, the standard exempt assets. You don't need an entity. You don't need any special titling. Trusts, which are the oldest really form of asset protection, whereby a settlor contributes an asset into a trust for someone else. So the asset is contributed into a trust. A trustee has legal title. The beneficiary has beneficial title. If either is sued, they can't reach the asset. You have the divided title, and that's what creates that asset protection. We'll talk about creating your own trust in a later slide, but that's really a new concept. And then you have the business entities like the LLC. At this point, the corporation is pretty much outdated. You can go public with a corporation, but there's really no reason to start a small corporation whereby if an owner sued, you lose the stock. With an LLC, if properly formed, you don't lose the equity. We just noted this. Corporations, you can operate the corporation, and anything that happens in the operations of the corporation, the owners aren't liable for in general, unless there's some kind of fraud. That's inside asset protection. The problem with corporation is if an owner is sued from the outside, they lose a stock. There's no protection over the stock. If you have a question, please feel free to put it into the chat box, and Tony will let me know and send me the question. You can interrupt me anytime you want. Everybody's got different situations and different questions, no problem. I note here on the slide, reverse veil piercing. So that's when they're saying, we're going to sue an owner and we're going to break into the assets of the entity. In corporations, basically, the reverse veil piercing is taking the equity and then acting as a shareholder, trying to create a liquidation to reach the assets of the entity. And with charging order entities like LLCs, you can sue an owner, but the general rule is you can only lien the equity, so that you can't reach into the entity for its assets. You can't vote, this type of thing. That's the outside asset protection. Almost every state's different at this point, so you have to be very careful with which state you choose for your LLC. Some states allow for foreclosure of a single member LLC. Some states don't protect people who are single member LLCs. There's a lot of weaknesses in many of the statutes, including Florida, which is pretty much given up on the single member LLC. The multi-member in Florida is protected. Also, the anonymity, a lot of people like anonymity. Delaware is the only state offering the anonymity in the LLC. These are some of the precursors to the idea of the charging order, where you can't take the equity, you can only lien with this charging lien equity if you sue the owner. And it started in the partnership world. We've got way too much to cover to go into all the partnership stuff, because essentially they've become archaic. There's no reason to use the partnerships at this point. Here are some of the other features of limited liability companies as compared to corporations. There's no annual minutes, there's relaxed paperwork. But because the structure is open with LLCs, the key is that you get the operating agreement right. You can pretty much put whatever you want in these operating agreements. There's some limitation, but it's very small. That's where we see people run into problems. People with big businesses, ultra high net worth people, are creating these I know it sounds crazy, but they're actually doing a lot of this stuff themselves. And they actually create rights and privileges for people that is unintended. We've had litigation over the years where a minority person has tied up a company completely because the operating agreement was just put together in the wrong way. So you have to choose the right jurisdiction with respect to the LLC. They all are different. They are all different. A lot of it comes down to this internal affairs doctrine, where for years with corporations, if you created a Delaware corporation, Florida had an internal affairs statute which says we will respect the internal affairs of other states, things you create in other states. So if board members in Delaware, in a Delaware entity, are not liable for certain issues in terms of the corporate responsibility, Florida would respect that. You created a Delaware, you operate through the Delaware, where any those board members are not liable. So my argument is, well, if we create a Delaware LLC and it's got a more protective statute than the Florida LLC, Florida court should just respect the Delaware terms of its LLC. It's like a currency. It's a different currency. That hasn't really happened. When you go into litigation and you want, and someone's a bad actor and you want to get into that LLC, courts have pretty much tried to come up with every possible angle to get into these LLCs. But when you choose your LLC, you might as well choose the most protective one, because typically it's upheld, but it's not always upheld. Here are some of the benefits of certain statutes over others: the statute of limitations, inside transfers, and this charging order. Examples with respect to choice of law are pretty interesting, but kind of come up when someone does something wrong. It's not your general contract litigation. In this Wells Fargo v. Barber, for instance, a woman defaulted on a huge real estate loan, started doing all kinds of fraudulent transfer, which is moving assets into protective entities as a reaction to avoid a creditor, which doesn't work. So you have every state and most countries have a statute that says the plaintiff trying to get money out of the debtor can go after the recipient in a fraudulent transfer. That case is really a fraudulent transfer case. It wasn't handled that way, but the takeaway is she moved money into a Nevis LLC, with a very sophisticated entity, Nevis LLC, as I think it was really a fraudulent transfer. But the court, instead of going into that analysis, really said, well, she's here in Florida. So what we're going to do is we're going to say it's not really a Nevis LLC. We're going to treat it like a Florida LLC. And it's a single member. So we're just going to allow the plaintiff, Wells Fargo, to break through that entity and grab all the assets that she erroneously left in Florida as well. So is that going to happen every time? Probably not. But if you have a bad actor, you can pretty much expect the court to do whatever it needs to do to get those assets. I'm not sure why it went through that rigmarole by calling the Nevis LLC a Florida LLC, but you just have to keep in mind that the idea is on a sunny day, you do your planning, and it's very likely to be upheld. It's these fraudulent transfer issues, these criminal issues. That's when you run into problems. In J.P. Morgan, that's a good example. You had contract litigation in Arizona, and so the defendant loses, becomes a judgment debtor. Judgment debtor has LLCs in Colorado, and the plaintiff went to Colorado to sue the defendant to get to those LLCs. Now, the Colorado statute was fairly protective, and when you're in the state where the LLC is formed, the court typically is going to uphold its state statute, so they couldn't collect. The question is, what happens now? What would have happened if the plaintiff sued in Arizona to collect the Colorado LLC? Well, what happened in Barber, the case above it there, is the Florida court said, well, we're just going to ignore the protections of the Nevis LLC. And you'll find that strategically you want to pull the case into a court that's totally happy to ignore a foreign LLC, or in this case, an LLC in another state. They didn't do that, and they lost the case. Arroyos is a similar example, even stronger example, where you had litigation in the state of Maine, and it was brought into Alabama. There was a judgment in Maine, brought into Alabama, and the Alabama court's looking at collecting a Delaware LLC. And instead of saying, well, let's go ahead, we think Delaware law applies. It didn't say that. The Alabama court could actually apply Delaware law to the matter and either allow the collection or not. The Alabama court said, no, we don't know anything about Delaware. You go, if you wanna collect, you go to Delaware and collect, which is very, very debtor friendly. So that means every time you form an entity and it's in a state that you're not dealing with it, that the defendant has to go to that state to sue. That's very protective. Is that going to happen every time? Probably not. And then we go through which is correct, what's going to happen in your case. Who knows what's going to happen in your case, but we do know, and we've never had in almost 30 years now, 30 years in August, we've never had a plan breached where it was clear day. We moved assets in, we created a plan, and we operated through the plan. We've never had one breached. Here are some other issues with respect to LLCs. Basically, this is how the single member LLC, this idea of breaking into an LLC if it's a single member, started. It came from the partnership world, the idea of a charging order. If I have a partner and they're sued, why should I suffer if the partner's sued? Let them just lien out the partner. And that's the end of it. If we make a distribution, the partner has to pay the distribution to the creditor, but the partner is not, the partner who's not in litigation is not impacted by the claim. So in Albright, which is a movie star, went into bankruptcy. They're like, well, we understand you've got this protective LLC, but really it's not protective because 250 years ago when they started doing this, the idea was you had to have a partner. She had no partner, so they took it. Now, I had said that a lot of these cases come from bad actors. A lot of them come from bankruptcy as well, because the bankruptcy courts, really a lot of the restrictions on the courts are lifted. Someone goes into bankruptcy, they want their debts discharged. The debts are discharged, they're happy. Well, the court at that point, well, you've had your debts discharged. Let's take a look at the assets now. And if you say, well, I've got this LLC, but it's protected by the charging order protection, the court has a lot of leeway to take that LLC. It's not the same as a regular state court. You got to be very careful going into bankruptcy if you have assets. In Florida, this is the Florida example. Olmsted actually was not a bankruptcy case, but it was a bad actor again, a credit card scammer who had several single member LLCs. This was a multi-year debacle where the FTC sued him and certified to no one can do this. I mean, essentially, the cost of this for an individual is absurd. And the Florida Supreme Court did rule that a single member LLC was exposed, actually went completely over the rails and suggested that a multi-member LLC was exposed. So the whole banking industry and the bar got involved and they had to redraft the whole statute, but they actually retained the exposure of the single member LLC in Florida. Nevada is very good. Wyoming, Nevada and Wyoming. Wyoming we don't use anymore because of what's called the Green Hunter case. They broke through a Wyoming LLC and it was a very odd rationale, but that's a different seminar. Essentially, if you've got the single member LLC, even if you're in a Delaware and you don't live in Delaware, for instance, you want to try to add a child's trust, some other member if you can. What's another member? Is then the question. Well, is it 1%? Is it 3%? I mean, we get this question every day, essentially. The only court that we know of at this point really to get anywhere near addressing was a California court where a very wealthy individual, so here's your high net worth individual, does a family organization LLC with a number of trusts, puts hundreds of millions of dollars into the structure and puts the wife on for 1%. Well, don't know, what the guidance was there. Don't know, what lawyers were involved or not involved. So what happened is that he gets into a dispute for a few $1 million, which was nothing apparently to this guy Baldwin, and he keeps his family entity, makes $178 million in distributions, right? Before the charging order decides, okay, look, now we have a charging order because he got sued and lost. We're not going to make any distributions. You're going to have to sit out there, plaintiff, judgment holder, until we're ready to make distributions. You're out of luck, right? And so they go through this rigor. The creditor, plaintiff, loses in court, goes into appeal, and the appeals court says, we don't like this idea of adding the wife for one. They didn't exactly say it like this, for 1%, because it's kind of silly. So we're going to allow it. We're going to allow you to have another trial or go back and do a motion to break through this LLC. By the way, it was a Delaware LLC and Delaware single member LLC. The single member is protected, but there was no discussion of it, which is super interesting, actually, on the academic side. So, but now we know. So if you're going to play around with it, and the guy who's worth $300 million puts the wife on for 1%, and maybe a trust for the kid on for 1%, that's not going to do it. That's not going to do it. You really want these business entities to look like, even if it's an investment business entity, to look like if you make a gift or you may add someone as a partner, they're a real partner. And I think, although I'm not happy about it, I think that this Kirchie case is a precursor to really where the whole area is going to go. A number of courts have still upheld it. They just go by the statute. The statute says it's protective. If you've got more than one owner, you got more than one owner. That's it. It's protective. I think that's not the way the courts are going to go, but that's just a guess. And here's where we had noted to add a member. What do? You add kids, you add trust, you add brothers and sisters. Does it work? I don't know. We don't know yet. You can use an offshore LLC. You typically want to fund those offshore. I had a hand in this Nevis statute. It's very protective. The statute of limitations on what we were calling fraudulent transfers is very quick. You have to get to them very quickly. The charging order protection is very strong. It's very good, but it's really for assets offshore. When you have husband and wife involved in these, you should use tenancy by the entirety, where they own together. So even if it's an LLC, they have that second layer on top where they both own and they both have to be liable before anyone can do anything with that equity. And then when we have a single person, we add a self-settled trust. So 18 states say you can create your own trust and it's protective if you follow the rules. Well, where you can't have that TBE at the top, but maybe you have kids, you have trust for your kids, you have a multi-member, but you're saying, if I lose the case, I can still get liened. I can't get any money out of this LLC. We create a self-settled trust. And the self-settled trust rules, we like Nevada a lot, say, no, you cannot even lien that, because the defendant is not the trust. That's not the debtor. And it has worked. We have defended it a few times. Occasionally it doesn't work. We can go through a couple of the examples here. Here, if we go back through how trusts work, it's this divided title between the trustee and the beneficiaries. There's different kinds of trusts. Revocable trusts are essentially worthless from a protective standpoint. Also, you got to be careful with a revocable trust, because a lot of times it will stop you from creating this protection for tenancy by the entirety. If mom and dad have a revocable trust, you have not joined those assets. There's some academic work now going on and in Delaware where you can create a revocable trust if you're obsessed with the revocable trust, where you get the tenancy by the entirety protection. I would just do tenancy by the entirety, because the whole idea is this probate avoidance. If I'm in a trust, there's no probate on the tenancy by the entirety assets. It automatically goes outside of probate. to the survivor. When we talk about domestic trusts versus foreign trusts, I like an array for diversity, but the domestic trust is subject to the full faith and credit of the U.S. Constitution. If I get a judgment in one state, they have to honor it in every other state. Well, they have to honor it in the state where I've got the trust. So that's a little bit of a weakness. The foreign trust is more protective, but it's really applicable to assets you hold offshore. Here's the self-settled trust. It's not in every state. Florida, if you create your own trust, it is not protective. Although once a month, someone will call us and say their banker said, as long as you use a corporate trustee, it's protective. No idea why people are telling people that. On the domestic side, there are some odd cases. Uber, for instance, if you go bankrupt, I think the likelihood is probably no greater than 50-50 that they're going to uphold the protections of a self-settled trust. In Uber, this was a Washington State bankruptcy. The guy was in Washington State. The trust was in Alaska. He basically had no connection to Alaska. All the assets, people, co-trustee was in Washington State. So what the bankruptcy court has the power to just say, well, for public policy purposes, this is a joke. We're going to disregard it. Or it says, we're going to call it a Washington State trust, and Washington State does not recognize the ability to do a self-settled trust. If you do your own trust, it's not protected. So now it's Washington State. It doesn't create any protection. We're going to take all the assets. Uber is more of an entertainment deal where a mountain man created his own, and he succeeded. He created his own asset protection trust in Alaska. And there's a fraudulent transfer statute in Alaska. I think it's a 4-year statute. The 4 years had passed. He was protected. He then gets a divorce. He had the argument, well, you can sue me. I'm protected in trust. There's no fraudulent transfer claim because the 4 years had passed. 4 years after funding, you can't sue. But he went bankrupt, and the bankruptcy extends the statute to 10 years, and the spouse got into the assets. Interesting case. Trustco is a similar case whereby we always emphasize when you create the structure, let's go ahead and tell your creditors that you created it. That will start the 4-year statute. In Nevada, it's the 2-year, but in general, it's 4 or 6 years, depending on the state. Otherwise, if the creditor can argue, I didn't know about the transfer, it'll typically be 1 year from the time of knowledge, whenever that is, 6, 8, 10 years out. So you want to start that statute. These are some of the cases that some of the self-settled trusts, domestic asset protection trusts, require very specific affidavits and financial claims as part of the filing. And then, of course, you can't do a sham where you're putting money into a trust, but you're the sole beneficiary. You control everything. The courts will never respect that. You can segregate. This is just more detail on the same thing. Here's some of this is an older chart. We've got foreign trust jurisdictions, and the protections are absolutely amazing on some of these foreign trust jurisdictions where fraudulent transfer, it's very hard to prove. You have to post a bond to sue. It's very hard to get into things. But the bottom line is, if someone's in the U.S. and you have money in a foreign trust or an account in a foreign trust and it's offshore, the connection to the trust is lost with respect to the local judge. So there are some things that they can do if, in fact, there's a fraudulent transfer, but it's limited. They can't reach the asset. They don't have jurisdiction over it. And these are just some general pieces with the foreign trust. There is substantial additional tax compliance. That's just really part of your return every year. It is additional though, and you'll have to deal with a foreign trustee. You can still manage all the investments. The foreign trustee just basically takes a fee for being a foreign trustee. Let me see something. Yeah. We talked about how courts reach into a foreign trust. When you have an high net worth person and they create a foreign trust on a sunny day, how do they reach in? They don't. They don't reach in. It just doesn't happen. So you have to have a situation where the fraudulent where they're running away from a creditor, or there's some kind of malicious activity. It got even to the point where if you had corporate stock and you move the certificates offshore, the plaintiff couldn't get to the corporate stock because the certificates were offshore. That was a very questionable ruling, which was recently overturned. That's the Sargent ruling that was overturned by this Bushel v. Shim ruling, whereby if you're moving things in fraudulent transfer, they can put you in jail for civil contempt until you bring those certificates back or that money back to pay the plaintiff creditor. The Rush University is an interesting case. It really comes from what was known as the Portnoy line of cases, whereby if you have a foreign trust, in this case, the grantor had pledged money to Rush University Medical Center, but when he died, the pledge was supposed to come through. They had relied substantially on the gift and went to court and said, we relied on this gift. The family said, no, it's all protected. And they lost it because it was kind of a bad faith gesture. You have to be careful with that. These are just some of the things you should avoid with respect to having too much control over your trust or your LLC. That's an alter ego and a sham. It's really just you're paying your debts. So if you have a trust or no, you don't want it paying your electrical bill. You don't want payments coming out every day, every moment. You don't want to actually control it like by the second. You can make the investments, etc., but you want like a quarterly distribution, this kind of thing. This is what the courts do in terms of this civil contempt I was telling you about. So you want to create a connection to these trusts. You want to be in the jurisdiction. You want to have investments in the jurisdiction. You need a trustee in the jurisdiction. Avoid bankruptcy. That's a good one. Here's some background on the estate. How we doing on time? So we have a little bit of time left. For your ultra high net worth, this is really, really a key to the whole thing. We can create these structures and we can do it in a protective way, and we can do it whereby they can reduce the estate and gift tax. There's a huge credit now. It's just $25,000 per couple, 12 each, and they should use it. And not only can they use it, but we can do it in a way where the gifts that come out, if they give $1 million for income tax, estate and gift tax purposes, you can get something worth $1 million really down to, for tax purposes, worth $600,000. And on a really aggregate basis, you can save a huge amount of money doing that. And then even you can keep the income, which will reduce the gift even further, get blocks of assets out of the estate. You just always have to keep in mind the distinctions between the income and the estate tax. Income tax is determined in terms of foreigners and domestic people. Totally different. So if you're a citizen, you're subject to income tax worldwide. A lot of people I had a call yesterday out of state. They think if they leave the country, they're not subject to income tax. No, they're subject to U.S. income tax. There's credits that they can get and maybe treaty, some benefits from a treaty. Whereas foreign people are only subject to income tax on U.S. source income. And there is no capital gains. And essentially, there's no capital gains for foreign people. Estate tax is not so much this citizenship the time you spend in the country, that's an income tax thing. Estate taxes, are you a citizen? Are you a resident? In other words, you're here and you want to stay here. If you're not a resident, you're not subject to estate tax unless the asset's here, and that's an easy fix. We can just create a foreign entity, and with that foreign entity, foreigners can buy assets in the U.S. And avoid any estate tax ever, anytime. On the income tax side, for non-resident, non-citizens, it's very limited, right? You can buy and sell stock, there's no tax. You may have a treaty, which completely avoids tax. You've got this issue with income on rents and passive things like interest, depending on the note, you can get out of the interest. And it's basically a graduated rate. Foreign trusts are considered foreign, or taxed like foreign individuals. On the estate tax, it's very favorable, but you have to be careful. You have to be careful. If you're not here and don't intend to stay, you're foreign, totally foreign. You're only taxed on what's here, and you can avoid that through the foreign entity, foreign LLC usually, or foreign trust really. But if you don't do the foreign entity or foreign trust, you're going to run into almost $60,000 exemption, nothing. So if you die and you have assets here, and you're a non-citizen, non-resident, you're going to pay 40% on the value of those assets. You got to be very, very careful with that. This goes into what is a foreign trust, what's not a foreign trust. Essentially, you have to form it abroad, and you cannot have a U.S. person managing it. If you do those, if you follow those two rules, you avoid the foreign trust status. This is an interesting area, the 684, 679 area. If we're in the U.S. and we move assets to a foreign trust, 684 says it's as if we sold them. You have to pay capital gains on all those, even though you got no cash. It's as if you sold it because it's leaving the country. They don't like when things leave the country. If you're U.S. and you have U.S. beneficiaries, they say, well, we're going to hold it off until that. It's grantor status. If it's grantor status, there's no deemed sale until death. At death, usually it's okay because that's when you get the step up and there's no gain. That deemed sale doesn't occur. It occurs, but there's no gain. But if you move that stuff offshore and you gave it away and you eliminated that from your taxable estate, you got to be very careful because when you die, there's a deemed sale of that asset on the income tax side. Very complicated, but very dangerous without a lawyer. And then, of course, there's treaties, which depending on the treaty and the country, it is limited. It's mostly the Eurozone, Asia. We don't have treaties with South America and the Caribbean in general, where you can eliminate tax or you can reduce the rate. We'll spend a couple minutes that we have left on expatriation. People say, well, why am I going to expatriate? It's not expatriation for tax purposes does include citizens who leave. Okay, but really where the volume of it is, if someone's here for 8 years on a green card, a non-citizen, and they give up the green card, it's a tax expatriation. Very, very odd. A lot of people aren't aware of it, and a lot of mistakes are made. When you expatriate, so it's 8 years, that's who's covered. When you expatriate, there's an exit tax. We'll cover the inheritance tax. It's a little more obscure, but there's an exit tax. Deemed sale of everything you have worldwide. So when the mom and dad from Brazil came in, they got a green card after they had a visa because they liked it. They initially came because the kids were in college. If that 8 years passes and they decide, well, we don't really want to be taxed worldwide anymore by the US, we're going to give up the green card. Be careful. It's not just the US assets, it's worldwide. They're taxed on the gain of from the sale of everything. It's an eye opener. Let's just put it that way when they're in your office. It's an eye opener. So you have this exit tax, which I mentioned. You also have the inheritance tax, which means once I leave and I go either as a citizen or as a resident, I give up a green card or citizenship. Really, the IRS says you can't send money back. If you send money back into the States, it's not, although you're non-resident, non-citizen now, we're not going to treat you like one, because non-resident, non-citizens can move money that's abroad to recipients in the US. There's no tax. They say no, the recipient has to pay a 40% flat rate on the value. Very, very onerous. Here's who it applies to. You've got to make a certain amount of money every year, or you've got to be worth $2 million, or you fail to comply with the tax rules. So there's some thresholds in terms of income and net worth, but that's the imposition. If you don't make one of the exemptions, it imposes this mark-to-market sale on you, as well as the inheritance tax. Here's the thresholds again. This is really based on the calculation. One thing to keep in mind is also there's an exemption amount with respect to the minimum amount of associated assets with the gain, and it's $767,000 for 22. I didn't calculate it yet for 23. Here's the inheritance tax. Again, I want to grab the last couple slides so you hear about some of the pre-immigration. If you have questions, my information is going to be at the end of the presentation. This stuff gets a little obscure, but the idea is if you go and you give them the green card or your citizenship, there's a tax. And not only that, there's a tax if you want to send money back in. And you can mitigate some of these taxes potentially. We deal with the ultra high, and that's what this seminar is about. But some of the people that are going to be kind of flipping into the $4, $6, $8 million net worth, there's some things they can do gifting, they can sell their personal residence. You know, you still get the $500,000 exemption. You get that net worth down so that you qualify for an exemption. And then the last thing we covered today, I wanted to just hit some of the high points, are people who want to come into the States. So I think the last thing you want to do is bring this ultra high net worth assets into the States and then have to do your planning. The idea is let's get it into a foreign trust a lot of times for the family before you come in. By the way, for the advisors out there, this is one of the most difficult areas, because unless it's a client very sophisticated and aware of how the US operates, a lot of people are going to be very reluctant to give up absolute control over their assets before coming in. It's a little bit of a frustrating area, but with the right client, you can save a huge amount of tax. Otherwise, they bring it in. And you get back into the minimum exemptions. You have to use a unified credit. You're doing your grats and your cuperts again. If they don't, they can leave it out. Here are the exemption rates again. They go from non-citizen status, non-resident, where everything outside they can gift, there's no US tax, to resident. And then everything they gift is subject to the gift tax. They have the exemption, but some of these people are very wealthy. Here's the income tax versus the estate tax, right? I can be subject to the income tax because I've been here for a while, but I don't want to stay. I'm not subject to the estate tax. I can gift freely. All of these issues we go through when we do our initial analysis. This again talks about how a non-resident, non-citizen is taxed by the US on the estate and gift. although it's onerous with respect to the assets in the States, you can eliminate that through the foreign entity. It's very, really flexible with respect to assets outside the state. There's just no jurisdiction by the IRS until you decide to come in. Here's some of the exemptions again. So you gift out prior to residency, you do the best you can. Typically, you focus on foreign assets because you've only got the $60,000 credit on your U.S. assets. If you've properly planned and you've got your U.S. assets in a foreign entity, you can start gifting on the foreign entity. That is not subject to gift tax. That's an exclusion. And you can use your foreign trust with respect to the gifts. You don't have to give to the kids directly. You get back into that 679, 684 rule. When you come in, you're deemed to have funded a foreign trust, which clicks that deemed sale unless you have U.S. beneficiaries. If you have U.S. beneficiaries, it happens at death. So what happens is you almost always have U.S. beneficiaries if you're coming in. You leave the assets in the foreign trust, your estate and gift tax is all set. You come in, you clip that provision. Now, before you die, you can domesticate the foreign trust and you avoid the deemed sale at death. Now you know what I know. Call me or email me at this address if you have any questions. Also, I've written a couple books on these topics. We can send you a book. We always send our books out for free to attendees of our webinar. Thanks so much for attending.